good to go. Thanks, Alec. Oh, we are live. Whoops.
Yeah.
That's all right. Sometimes I'm talking about instructions and I forget that I should be watching for when we go live. But hello, everyone. Welcome to Legal Lunch and Learn, a weekly live show where we ask an expert your questions on a legal topic. My name is Cindy. I am a staff attorney here at Maryland Legal Aid. My co-host today is another staff attorney here, Tim Darby. Hi, Tim. How are you?
I'm good. How are you, Cindy?
Yep. As usual, our production engineer is Alec Chase. And joining us today is our housing law expert, Douglas Nivens.
No problem.
Hi, Doug.
No problem. Thank you for having
I'm sorry.
me.
Do you prefer Douglas? I should have asked.
It's fine by me. If you want to think about the 90s cartoon, go for it.
All right. So our topic today is what to do if you're facing evictions, and of course, a brief rent court update from Douglas as well. So if you do have questions about evictions or rent court right now, post your questions in the comment section down below, or you can, if you want to remain anonymous, you can also private message us. And of course, as I always say, if you have an immediate legal issue or if you want to talk to an attorney for free one-on-one, make sure you're contacting us and we'll post our information down below. But our email here is lawyer@mdlab.org. That's LAWYER@mdlab.org. Or you can call us. Our phone number here is 443-451-2805. And of course, for those who do need captions, we do upload these videos to YouTube after our live session is over. So you can check those out as well. And of course, before we get started, a very serious disclaimer: just because you watch our videos every week, or if you take some legal advice from our videos, it does not establish an attorney-client relationship between any of our attorney you see here today and you, or with Maryland Legal Aid. So again, if you do have a legal issue, you want to talk to a free lawyer, please contact us. So with all of that out of the way, hi, Douglas. How are you today?
So far, so good. I'm well caffeinated. How are you?
I am also well caffeinated, which is good because it's noon and I am running a little hungry, but we will power through all of this.
So I believe in you.
I try to eat before we start, so I'm not getting a little hangry while we're doing this live. But sometimes, you just have too many things happening, and lunch will take a back seat sometimes. But
no, it's okay. Hangry to me is a trial strategy. No problem.
Oh, it is. It definitely is. But so let's talk a little bit about you before we get started. I actually don't know you very well. Some of the experts we have on the show, I've known them for years, but you, I don't actually know that well. So talk to us a little bit about your experience.
The reason probably because I'm always in court a lot of times. So I am one of the more newer staff attorneys. I was hired in Maryland Legal Aid in August of 2019, back in the day before there was COVID. So I'm part of the Housing Consumer Law Unit. So my primary focus is in landlord-tenant actions, especially rent court, rent escrow proceedings. Time to time we deal with tenant holding overs and breach of leases and wrongful detainers. But that's really mostly my wheelhouse at present. Prior to Maryland Legal Aid, I also was in 10 years, I was an analyst in the federal government. So
Oh my gosh, I did not know that.
Yeah, fun times. Yeah,
that's very impressive.
Yeah, I had 1 year I was able to work in the Obama White House for their federal spending portfolio. So when it comes to a lot of just dealing with spending, it kind of was a good crossover coming to housing, since a lot of the disputes is about how much rent do I owe, and there's questions over, well, rent was really due and owing at that time.
Right. Absolutely. So I'm so glad to have you on the show. With all of that, let's just dive into the topic for today. So for the listeners out there, we're going to just briefly walk through what the legal eviction process is and talk about the little things that might come up along the way. And then we'll go ahead and talk about what's actually happening in courts right now and what you should expect when you go into court. So start all the way from the beginning, Douglas. So let's say, let's really not talk about why a landlord wants me to leave. Let's just start the process that a landlord basically saying, get out. So what usually
Okay.
happens next?
Okay. Well, I would say call a lawyer,
Yes.
especially if somebody's trying to take away your property and you feel as though you have a good reason to stay there. By all means, contact a lawyer about that. But one thing just always remember when it comes to Maryland law, regardless of your Baltimore City, where I primarily practice, or you're somewhere even on the Eastern Shore here, that in order for a landlord to evict a person from the premises, it must go through the courts. It must be some time where you are given notice, you are summoned to court, and you can have the opportunity to tell the judge your defense over why you should be able to keep your place or leave. So let's say, for example, let's say the reason why the judge wants you to leave. Oh, sorry, the judge. I apologize. The landlord wants you to leave because you haven't paid rent. Okay, so at that point, it'll be a failure to pay rent action. They'll have to file, and they are able to file that normally 5 days. If your rent's due in the first of the month, we usually give you 5-day leeway just in case you actually mail in that rent check. But usually after the fifth of the month, landlords are able to come to court and file a failure to pay rent action.
So
Now,
once they file it, do you get
mhm,
something official from the court?
yes, you will. For most tenants, you'll be getting a notice. One will be either mailed to you from the courthouse, which will be the summons. It'll show the premises, your name, how much you are allegedly due and owing to the landlord. It should also have information about their lit certificate. If they have a license, registration number. All that information will be on that complaint. And ordinarily, when it's mailed to the tenant from the um, it would be mailed from the sheriff's office a lot of places, sometime from the courthouse. And also the sheriff will come to the premises and tape the notice on your door. We colloquially call it, I think it's not posting, some say it's nailing, but either way, you're supposed to get those two notices that a court date is coming up.
Right.
For certain residents who live in a federal subsidized property, they should also gotten a 30-day notice from their landlord saying that they're going to file a rent court action.
Okay. So if the landlord, let's say it's a private landlord and you're a private
Okay.
renter, it doesn't go through housing.
Okay.
Do they have to tell you before they file something in court, or can they just do it?
No, they could just do it. I mean, that's the right of the landlord. Say, hey, this person's living here, not paying my rent. I want them to leave. So you may not say get any other notice other than the summons in the mail. And that's why it's important that if you get that summons, you should contact a lawyer, and also you should go to court. If you
Yeah.
don't go to
So
court, you can't have your say.
yes, we'll go to the court section in
Yeah.
a little bit, in a bit here, and I just want to emphasize here, and you know the answer to this, but I will ask anyway. How soon should you ask for a lawyer or reach out to a lawyer?
As soon as you get notice,
Yeah.
as soon as you receive it in the mail, soon. Because honestly, the more time you have to build your case, the better able to represent a person or figure out what their rights are, what strategy, or even negotiate if that's even a possibility. But it's kind of hard to do all that work if you come like the day before your hearing.
Right. Absolutely. And sometimes, if you go to see a lawyer the day before your hearing, you might not have all the documents an attorney might need to do an effective defense,
Mhm.
for your case. So let's talk about the things that you might be able to take with you to court to help your case a little bit. Can you, let's start with what if I have documents? So we're in COVID pandemic right now, and there are things that you can show to the judge saying that, hey, I lost my job due to COVID. So two things I want to talk about first. Is there any
Okay.
kind of defense you can raise because of COVID? Like if you lost your job or if you
Mhm.
can't work because of COVID?
Yeah, so there's a couple of defenses available right now. First, it is Governor Hogan's executive order that allows tenants to raise as a defense to say that they weren't able to pay rent because of substantial loss of income. And that could be any other ways. Most commonly, you lost your job, reduction of work hours. Um, Even, for example, you had temporary closure of your workplace because say you work in an industry that had to close in the earlier stages of the recovery, or your jurisdiction is still, let's say, phase two, where other portions of states are not. And also for some folks, you have to stay at home more often because you have a child who is homebound and you need somebody to supervise your child so they can get done with their studies, and that affects your income. The big thing though is that a tenant has to show what's called objective proof of this loss of income. So most commonly that could be a letter from your employer that says, hey, this person, I had to reduce your hours due to COVID, or you know, you lost your job because of COVID. Some type of proof, preferably in a document, that backs up that you were affected by the pandemic.
Would the judge allow you to I mean, we're lawyers, so we say like we'll allow you to testify. So would you be able
Yes.
to tell the judge, well, I don't have anything in paper, but
Mhm.
I can't find a job due to COVID, or this is usually what I do, and that industry is just hard right now.
Well, a person, especially if they represent themselves, can always proffer their own testimony. I mean, it is your lived experiences, but you're also trying to convince this neutral third party judge who maybe they will believe your testimony and take that as proof. Or it could be a judge who says, no, I need more information here. So it is a risk that you want to go into the courtroom without any documents to say, hey, believe me, I've been affected. The judge doesn't have to accept that. Now, there's also another defense, and that's from the CDC temporary eviction moratorium. It was a regulation that was issued September 4th, and it lasts, at least currently, through the end of the year, so through New Year's Eve 2020. That too is an opportunity where a tenant of a low income, especially individuals who, for example, received their stimulus check from the spring, you will qualify. But the essence is if you give a declaration to the landlord that says, hey, I know I owe you rent, and yet I'm suffering from substantial loss of income, I'm going to use every available means to get government support to help pay my rent. And as circumstances warrant, I will also give you money as best as possible to pay my full rent. If a tenant completes the declaration under penalties of perjury, give it to the landlord in a rent court action, that should prevent the landlord from taking action against the tenant. Now, in practice, what that means, you may still go to court, and a judge may still say, yeah, rent is due and owing and you haven't paid it, and I recognize that you suffer from a substantial loss of income. I get all of that, and I got this declaration, I see you gave it. What the courts are currently doing is they are recognizing the amount owed, but they're not going to issue judgment, or reserving judgment, technical term, meaning that the landlord cannot complete the necessary steps to get an eviction because judgment is still held in the courthouse. And until the judge releases it, the tenant is able to stay without fear of an eviction, at least as it pertains to rent.
Yep. So that's my follow-up question. So this seems like a
Mhm.
very specific situation that one, it has to be a rent issue that you couldn't pay rent, and two, it has to be because you couldn't pay rent because of COVID. Is
And
that
that's now. I mean,
right
this
now?
is still changing circumstances. Something may change tomorrow or in the following weeks. So that's why, in terms of whoever, if you are viewing this on a day that's not October 13th, some things may change. We're all
Yep.
trying to be flexible in this pandemic.
Yep, absolutely. So, going back to this being a very specific situation, let's talk about what if a landlord is trying to evict you some other way? Because,
Okay.
so something I have noticed is that landlords are trying to wait until your lease runs out, and instead of
Mhm.
saying oh, failure to pay rent, they're saying, you know what, I don't
Mhm.
want to renew your lease. So now you're a tenant holding over, or you don't have a lease.
Mhm.
Is for the lay
Mhm.
people out there.
Yeah, tenant hold over.
Right. Do they, what changes legally? Can you still make the same argument in court saying that I can't pay because I lost my job due to COVID?
Hmm. It depends. And the variable here is who's sitting on the bench. So there are some judges who may entertain the governor or CDC order if it is found that the underlying reason for that notice to vacate is because of a failure to pay rent. However, not all judges accept that. Some judges say, look, the CDC order is only about rent. This is not a rent action, just a you overstayed your lease action, and therefore they may not allow it. And you're right, we see a lot of landlords who because they can't get rent because they because of the pandemic, or maybe they can't get rent because they're in Baltimore City, they don't have a license, so they're using tenant holding over. It's a popular cause of action because it's all about, hey, I ended your lease, you stayed over, you gotta leave. Money is not necessarily an issue. So in that circumstance, by all means, a tenant may raise it as a defense, but a judge doesn't have to accept it.
Yep. I think one of the things I do want to emphasize here is just that because of COVID, everything, all these laws and rules are so new. And I think for our viewers out there who are facing evictions, talk to an attorney, because a lot of times even the judges don't know how they want to rule on these things. And the better you can present that argument in front of a judge, I think the better your chances are going to be. And of course, a little plug here, Maryland Legal Aid does represent tenants for free. So if you do qualify for our services and you're facing eviction, make sure you're contacting us. So moving on to documents to bring to the court. Even outside of COVID season, let's say, I hate to call it a season because I have no idea when it's going to end.
I know.
I want it to end, but
we're in a soap opera. That's what it is. Never ending
absolutely
season.
Absolutely. Come on, vaccines, you can do it. But so let's talk about other actions that landlords take to get you evicted. What documents do you think will be helpful for someone to gather, either for their court hearing or for talking to an attorney?
Okay, so I would say that so that's one of the most popular ones out there is tenant holding over. So one thing to look at is what's in your lease. And so when talking about any type of matter, especially with an attorney, or even preparing to go to court, you should have a copy of your lease. Your receipts that show that you've made payments. You should also have any other document about what you've been living through. So maybe you didn't pay rent because there are damages in the premises and the landlord hasn't fixed it. So you may want to bring photos and video regarding the damage that you've been suffering through. If your landlord, and this is an example I had quite recently, we had a landlord who couldn't evict a tenant for failure to pay rent because the landlord didn't have a license in Baltimore City. So the landlord took the tenant again to court for a wrongful detainer, which is essentially saying, you're a squatter. I have no relationship with you. I don't know even who you are. You're not a tenant, and I want you gone. And one of the things we had to show in that hearing is the lease. We brought up the physical copy of the lease to show to the judge. We brought in receipts that the tenant had paid, throughout this current year, and said, look, the client, the tenant is a tenant, not a squatter, and the landlord took it to court on the wrong action, and the court agreed. The court's like, look, she's not a squatter. You've known her. You've taken her money from her. Just because you don't got a license doesn't mean that all of a sudden this relationship doesn't exist. It just means that you can't take the money. So the court dismissed it, and so she was able to keep her place to stay for the time being. But like I said, those things are very important. So if you don't have those documents at a secure place, I would highly recommend it, because oftentimes we do a lot of document review in these type of cases. What does your lease say? Is it a month? Is it a year? Those things matter over what your defense may be.
Yep, absolutely. And for those who want to contact Maryland Legal Aid for help, I think whenever I have a housing issue, the first thing I ask for is, well, I can't answer your question until I see a copy of your lease because I don't know what you agree to. So absolutely, bring your lease with you. And I think I do want to bring up something that you mentioned in another presentation that I attended and asked a million questions because you're so good at answering them. I think you had this tip about, bringing photos versus having your smartphone. Can you talk about that?
Yeah, so this is a request I've gotten from different judges on the bench who said, because a lot of us, our cell phones are like a part of our bodies. We take it all over with us. We take photos, not just of our housing conditions, but photos of everything else of our life, what have you. But the tip I say is that when people we see often, they'll have their photos on their phone, they go to court and say, Your Honor, my photos is here. And the judge's like, okay, well, I'll look at the photos on your phone. And there's been instances where people swipe too many times to the left. Or you find a situation where maybe the judge says, this is a really good evidence, and I'm sensing that this is a big case here. A judge don't have to let go of your phone. If you're submitting your phone as evidence, the court could keep it as part of its evidence, and therefore you'd be out of a phone. So one thing I highly recommend for people, if you're going to bring photos to the court that you want to show, print them out. Go to your local store, whether Walgreens, Target, what have you, print them out so that the judge can have a physical copy of what's going on in the premises. It's a whole lot more secure than handing your device to a to an official who could keep it.
Yep.
Video is a little different, understandably, but for photos, print them out.
Yep, absolutely. And of course, if you do have a lawyer, they might be able to help you bring a laptop to show to the judge. It's a better way of showing a video and better quality, or they can print out photos for you. And I definitely have done that for clients who just email me the information. So now that you talk to a lawyer that you're going to court, or you're going to court on your own, let's say you're going to court on your own for whatever reason. And let's talk about what rent court looks like right now, or eviction court looks like right now. So you walked in the courtroom, it's your court date. What do you expect in Baltimore City? So
Baltimore City, first thing first, just getting to the doors of the courthouse, everybody is subject to fill out a questionnaire asking about what their health or any symptoms that may suggest exposure to COVID-19. And once you pass through the questionnaire, you hand that to the bailiff. The bailiff will take your temperature to see if you're running a fever or not. And once you pass that security, you're going to go through your regular, ordinary security, metal detectors, what have you. Baltimore City Rent Court is almost always in courtroom number 2. It's the largest courtroom. It's on the first level. You go in, everybody has to check in with the courtroom clerk. Now, of course, I'm saying this out of assumption at this point, but everybody should have a mask on to cover their faces. And you're going to have to speak to a clerk who's going to be more than 6 feet away from you. So you're going to have to project. So if you're a person like me who's used to speaking at a software level, you have to be ready to yell beyond your mask to not only speak to the clerk, but also eventually speak to the judge, since those masks here tend to lower the projection of our voices, and all these hearings are recorded. So if you don't speak loudly enough, there won't be much of a record of what happens. But once you check in with the clerk, you take a sit down. There's the dockets right now are purposely reduced. So for the there's 4 dockets in the courtroom. The first 3 dockets are mostly for landlord agent cases. So they tend to be companies that represent large apartment complexes. So they may have about 50, 60 cases for their dockets. But the last docket, a 3 o'clock docket, are your individual landlords. And those are only going to hear about 30 cases. And that's to make sure there's not a whole lot of people in the courtroom. Well, let's say, regardless of your docket, if you're a tenant, you show up, you checked in, the courtroom clerk is going to call cases either by the tenant's name, the landlord's name, the street address, the case number. So you have to be hearing where your case may be called at a given time. Once that is done, you get, your call, you go before the court, not too far because things have been kind of restricted in terms of your access, but you got to speak to your judge who's surrounded by plexiglass, and the judge have their own mask on. So everybody has to speak loudly enough so that everything can be heard. But the court is going to ask really 2 basic questions. Is rent due and owing? And if so, how much? And there are some other issues that play in the background, but that's the central issue for the court. And it is the opportunity for the tenant to present the defense, why rent may or may not be due and owing.
Sorry to interrupt. Is this the situation? And I practice in a bunch of different courtrooms, but I
Yeah.
don't do rent court in Baltimore City. Is this the situation generally where you really have to advocate yourself? So or would the
Mhm.
judge kind of prompt you to say, do you have defense, or do you have to be like, well, wait, judge,
It depends on the judge. I mean,
Oh
every judge is
no.
unique. I know, because judges are people too, and everybody have their own style of how they move the dockets around. There's some judges who will say, look, if you have a rent escrow issue, i.e., I didn't pay because there's a serious threat to my life, health, and safety in the premises, that judge would say, look, may that be the first words out your mouth. Don't even say it. Just say, Your Honor, rent escrow. And that judge will say, well, you can go downstairs, you can file the paper for rent escrow, come back up. Some judges are like, I'm going to sit here silently and you tell me what you want me to hear. And once you're done, I'll make a decision. Some judges may poke and prod a little bit, depending upon what they see in that complaint, what they've heard from maybe other tenants with that same landlord, and may do some more questioning. The bottom line is that rent court is a fairly it's a very uh, low level in terms of the evidentiary bar, i.e., it's supposed to be a place where people can, regardless of your background, can speak your defense to the court, and the court is supposed to, and I think by and large the judges are understanding of what people are facing with this pandemic, how tough the job market is, and even the constraints that facing landlords who may or may not be able to fix the problems on the premises. So it is not as formal as say like the
Yep.
circuit court or lay court. It's
Yep.
it's the original people's court.
Yep,
Uh,
absolutely. So, and of course, I want to also emphasize that, if you do have an attorney, it's gonna make your life so much easier, because the attorney will be like,
yeah.
"Wait, judge, these are the points I'm trying to make," and if the judge missed something, your attorney will know
Mhm.
to mention it, and of course, then you
Mhm.
don't have to be saddled with the embarrassment of interrupting a judge, which I do sometimes. Um,
Yeah,
but
I was once called exuberant once for
yeah,
interrupting one of the
yeah.
judges. She's like, I'm sure your attorney, he's excited.
I prefer zealous.
I like
Yeah,
that
I
too.
think I used to do criminal law, and I think zealous is a term that I
Mhm.
would use often, and sometimes I put it on the record, and I would say I zealously object to this, Your Honor,
Yes.
or strenuously object
And
to this.
yes.
Yep.
And the one thing you get with an attorney is that you get somebody who already has a relationship with that judge, so they understand maybe what that particular judge want to hear or how they want to see evidence presented. Because like I said, everybody have their own style. And I know there's some judges for whom I'm gonna wear a bow tie and I'm gonna bring some Excel spreadsheets and we're gonna bring out the number. Some judges more like they want a story. They want to know the beginning, middle, end of what has happened. And you, with an attorney, one, that person's job is to build your strategy for you. Therefore, you, the client, don't have to worry about it. But you're also getting part of their access and knowledge of how that courtroom works. So I know there are certain agents who I've seen often enough who, if they see my name, they're going to want to work with me first because they're like, look, Douglas is only going to get involved because something's wrong with this case. Let's figure it out and maybe we can get a settlement or even a voluntary dismissal so we can save each other's time.
Yep.
That helps.
Yep, absolutely. And again, we've offer free services. Use us. So let's
Mhm.
move along. I know we're starting to run short time,
Yeah.
but we could just run over today. Why not? Because people need this information. So
Yeah.
let's talk about what happens after the court hearing. So you have your hearing.
Mhm.
Let's first talk about what if you lose the case and the judge says you owe the
Okay.
rent. Yep, and here's the judgment. Um,
Mhm.
what happens next?
Okay. Very good
Just
question.
very
Very, very
broadly.
good
Yeah.
question. Um, I know, because I have a whole big case about this issue. So, um, rent court has maybe the most shortest appeal time out of any action in the civil world. That means you have 4 days from the date of the court judgment to note your appeal. And so, often with an appeal, you're gonna have to pay the cost for filing that appeal, more likely an appeal bond, which may be ordinarily is the judgment amount. So if they say that you owe $700 for rent due and owing, you might have to pay that money to the court as a bond so that you can proceed on to an appellate hearing. And like I said, it gets a little bit more involved. Usually in appeal, it goes from district court to the circuit court of Baltimore City, if you're in Baltimore City. And depending upon the value, it could be heard on a record, it could be in de novo, which is like a brand new trial. So it's a big step. But also, tenants also have the right to file a post-judgment motion. So this would be a motion for a new hearing. Maybe there's other information that you didn't discover at that time that can, as you say, amend or alter judgment. This we see that frequently with license issues. In Baltimore City, you must have a license to rent property. No license, no rent. And where you have a landlord who say, or maybe they mistake, it could be a mistake. But if I thought I had a license, they put their registration number down, they got judgment against the tenant, but then the tenant belatedly finds out, wait a minute, they don't have a license. It expired some years ago. This is a bad number. So that would be an instance where a tenant will file that motion with the court explaining what went wrong and with proof. It's more than just the words that you say, is the evidence you can back it up with. And the Baltimore City Housing Department offer free copies to tenants documenting the licensing status of properties. And I would say for motions, you have, I would say about 10 to 30 days to file that motion with the court for it to have any real effect.
Right, but as soon as possible is definitely preferable.
Yes.
Well,
please.
I mean, more preferable that you have an attorney before all of this happens. But but let's say you lose, you get a judgment against you in court, but now you have the money to pay rent. Rather, is there anything you can do to not have that judgment anymore, or to stay in the apartment?
So the judgment is going to stay, but you can satisfy that judgment by paying the amount of rent due and owing with court costs. So there's usually that like I said, there's that 4-day appeal period where a tenant can file an appeal. But once that appeal period expired, the landlord can go to court and file what's called a warrant of restitution. And in it, that's pretty much the landlord asking, filing a petition with the court to order the sheriff to conduct the eviction. And so with that filing, it will also have, again, the judgment amount, how much was found due and owing, and also the due amount of court costs. So let's say you paid your rent the day after the rent court hearing. Well, it'll be whatever was due and owing plus $30. If the warrant of restitution has already been issued, which will be mailed to the tenant, it goes up by additional 50. So now it's going to be the judgment amount plus 80. And you can pay the cash, money order, certified check, whichever way you want. Make sure you get a receipt. And if you pay that amount before the sheriff arrives, you'll be able to keep possession. Now, we call that the right of redemption. That right, however, is not indefinite. So if a tenant has been found to have 4 prior rent court judgments, not months, judgments against them, the landlord can ask the court on judgment number 5, hey, we've been through this so many times, I want to take away that right of redemption. So I don't care how much money they pay me, I want them out. And the judge at hearing will verify those previous judgments. And if those are true, the court will sign off on foreclosing that right. And that means that when the sheriff arrives, doesn't matter how much you have to pay, you have to leave.
Right. And let's talk about the more practical aspect of it.
Yeah.
So once you get a judgment, how long before the sheriff comes to your house? So
in Baltimore City, it's going to be a minute. Because like I said, we have tens of thousands of rental properties here. And the sheriff right now, they too have reduced the number of evictions that they're conducting out. So even in pre-COVID times, I would say it would take probably about 6 weeks after the court date that you might have an eviction. These days, it's going to be probably a little bit longer than that. So I would say it for many, there is time to pay for it. And in Baltimore City, landlords must give tenants a 2-week notice of when the eviction is supposed to occur. And so in 2 weeks, it has to be a mailing to the tenant. And then 7 days prior, there must be an actual eviction notice posted on the door. So there's time built into the process to let the tenant know that an eviction is forthcoming.
Right. Could the tenant, and again, this is a practical question
Yeah,
because
no.
we do things in a practical way here. So once you know that the warrant registration is going out, you're getting
Mhm.
evicted, you have to leave. Would that would it be better for you at that point to just keep the money and just save it and try to apply for a new place and hopefully get a new place to move into 2 months?
It depends.
Or yeah,
I mean, are you saying if you don't have the right redemption or you do?
if you do.
Okay, you have the right. So I'll give you a little feedback. Whenever I talk to my clients going through intake, one of the first questions I ask is, what is it that you want? So if the tenant don't like the landlord, don't like the living conditions, they know an eviction is forthcoming and they want to leave, then it may be the best choice for the tenant to save their money and find a new place. Now, there are some risks to that. One risk is that by leaving, the premises will go back to the landlord because they may have the sheriff or even the tenant just give them the keys. And that for a lot of landlords, that's all they want. They just want the place back. But there are some landlords who want that money back. Now, ordinarily in rent court, the remedy that the landlord is trying to get is just the place back. They want the keys. However, the landlord still have the right to sue for that money. That still is out there. And so a landlord could, if they're able to find that tenant, sue them in small claims for the money due and owing. It's like a fine distinction, but there are landlords out there who will do that. Now, again, if you're a tenant who you have no other place to go, this is where you want to stay. And maybe you want to still assert the CDC defense. December 31st is yet to come. The tenant may still raise that CDC order. I will argue they can give them that declaration. And if and when the eviction occurs, if it occurs during this year, the tenant may ask that the sheriff bring this up to the judge on that day. So evictions are typically held like between 9 and 10 o'clock or 9 to 11. If there's any issue that rises during eviction, the deputy is supposed to direct the parties to go to the rent court judge. So that would be the 130 docket. Everybody shows up to go there. And there the tenant may raise a CDC order as a defense to say, look, I lost my job recently. I want to raise this, because I want to keep my place to stay. I'll pay them money when I can. And depending upon the judge, that may be allowed. I argue that that tenant should be able to raise a CDC order as his defense to any eviction between now and the end of the year. But again, that's an argument you have to be thinks at the end of those arguments.
Yep, I too read over the CDC order, and I think I do agree with you. I think that's for the lack of a better word, that's a spirit of the order.
Yeah.
However, courts parse it, however the courts have been apply it has been very different, for sure. But so we are running a little bit long, but I do want to give people an opportunity to ask questions. So let's go to Tim for questions from the audience.
All righty. So the first question we have, the news said no evictions can happen right now. Is that true? Can you hear me?
No, because certain evictions are happening. I hear you.
Okay.
I would say that says my internet connection is I'm in our offices, so maybe it's stable, maybe it's not. I would say that eviction can occur, it just depend upon the reason for it.
Okay.
So if people were found liable for breach of lease, tenant holder over, or wrongful detainers, especially for those hearings that happened back in July and August, the court is supposed to look at the warrant of restitutions or the eviction orders, on a case-by-case basis to see whether or not that eviction should go on. So that's
Got
why some people are still getting evicted. It's
Gotcha. Gotcha. All right. So the second question we have: does the landlord have to tell me he's evicting me? Does it have to
an
be?
eviction
Does it have
based
to be
on
in
rent.
writing? I'm sorry. I think our connection is really bad right now. Can
Oh no, I hear you.
Okay. Okay. So
Well,
did I,
I could do. Let's try. Okay. Hopefully. All right. Can you hear me now?
yes, I can hear you. That's great. All right.
Alrighty.
Cool. Cool. All right. So we have.
So if somebody wants to evict you, must be in writing. Um, Everybody's going to get eviction notice by way of the Constitution, because the landlord has to follow that in order to get an eviction approved by the court. So that's one form of notice.
Mhm.
But beyond that, they only require like the 2 week requirement of a eviction notice. That's only in rent cases. So if the eviction is based upon a breach of lease or tenant holding over or wrongful detainer, the sheriff office, as a courtesy, may give notice,
Mhm.
but the law doesn't require it.
Okay. Gotcha. The next question.
I'm going
How
to
do?
see if I can plug headphones in. Okay.
Okay. Next question is: how do I know if the notice I got is legal? I'm not sure if this is a notice from a landlord or a notice from the court.
Oh, Tim, can you hear me?
I can hear you now. Yes.
Okay, can you repeat your question one more time?
Sure. It's how do I know if the notice I got is legal? I am not sure if this is a notice from the landlord or a notice from the court.
Okay. So if it is a rent, if the eviction is based upon failure to pay rent,
Hmm.
then and you're in Baltimore City,
Hmm.
then that notice must have your case number. It must have the date that you had the court action, how much is due and owing. So you're able to verify with your own record from the case if that is true. Tenants may also contact the sheriff office to see, at least in Baltimore City, you can contact the sheriff office to see if your name is on the list. One thing that we have that's available to us illegally, we also get copies of the eviction list posted in the courthouse, and the eviction prevention unit in the courthouse, who also give out certain funding for tenants for back rent. They also have access to those lists. So you may contact the sheriff to get information about whether or not that is a legit notice. But I would say, I mean, by all means, definitely have a lawyer for that. But if you're in a wrongful detainer action or a tenant hold over breach of lease, again, sometimes the sheriffs may not give you that information.
Hmm.
Um, once you, if you're a tenant, once you get that warrant of restitution, you should know that an eviction is forthcoming.
Got it. So the next question: what do I do if my landlord is refusing to fix something in my apartment?
Okay. If your landlord refuses to fix something, um, you may avail yourself of something that's called rent escrow. It is where there are threats in your premises that may affect your life, health, and safety.
Hmm.
It can even be raised as a defense in rent court. Ideally, what you would do is you would put in writing what is the repair that you need done, give the landlord 30 days, and that doesn't happen, then you can go to court to file that action. Ideally, you would send this notice in certified mail, copies of the letter, so you can prove that, hey, I gave them notice. Another reason or way a tenant can give notice to the landlord is by calling 311. You can get a property maintenance inspector to visit the premises to see what are the conditions are there. Now, again, when it comes to rent escrow, it has to be true threat. So it cannot be cosmetic. It cannot be something that's maybe a good thing to repair, but it's not necessarily a threat.
Hmm.
But I think still is a good habit just to put in writing what's going on in the property so that if you want to value yourself a rent escrow, you may do so.
Okay. What if that person say, there is a genuine threat to health and safety in the unit. What if they just also can't pay their rent, if they can't pay money into an escrow account, even if it were set up?
So, very good question. So, you have every right as a tenant, regardless if you can pay your rent. The premises still must be habitable, and that's something that the landlord can't get away from merely because the tenant can't pay rent.
Mhm.
So, in that action, again, you should contact a lawyer because it could get a little complicated.
Mhm.
But one thing a tenant could argue is that bring up a rent escrow. Hey, these are the conditions, which is one way why I couldn't pay rent. But you could also further say, look, whatever rent that I may be liable for, I can't pay it because I have a substantial loss of income. And so what you're asking the court is, I want you to either reduce my rent to zero due to the conditions in the property, or you could say my ability to pay should at least be excused or at least delayed due to COVID-19, but the landlord still must make the repairs. That's one way a person may try rent escrow in this situation. Again, it's all dependent upon the facts that you have, the defenses that your landlord might offer, and what the judge decides. Again, another remedy is still calling 311 so that there be a inspector there, because once the city gets involved in inspection, they may also pursue environmental citations or fines against a landlord who fails to fix the place. There's, it's out the hands of the tenant once they make that call, but it still be some entity making sure that the landlord comply with just the basis of the housing code.
Gotcha. Next question. What do I do if my landlord is doing stuff like changing the lock or showing up at the apartment unannounced?
Okay. So as a tenant, one of the benefits of being a tenant is that you have the right to be able to, if you call quiet enjoyment, to enjoy your place without disturbances of the landlord infringing on your right to be there peacefully. So if landlords are supposed to give tenants presumably 24-hour notice before they come into the property. Anything shorter than that, the surprises that's unjustified, that could be trespassing.
Mm-hmm.
So by all means, if that is something that happens repeatedly, one, you can call the police, say, hey, this person is trespassing without any notice. They have no right to be here. Yeah, you may be the landlord, but you still got to give me notice before you walk up in here unannounced, especially if there's no reason, not a substantial reason why they have to be there unannounced. You can call the police for that and document that information. Take your own notes about what's going on in your premises so that if you forget, you have something to rely upon to figure out what happened there. But if there's any type of changing your locks, or one of my clients have boards nailed over top of your door, or yeah, very serious. That's called an illegal lockout or a self-help eviction. As I said earlier, you only get an eviction by order of the court. So anybody who takes those type of action, that's illegal. The first thing a tenant should do is call the police, so that they can have a police report that documents, hey, this is the action that the landlord has tried to do. And then take that report to the court commissioner's office, the district court commissioner, so you can swear out a criminal complaint for illegal lockout, because it is a misdemeanor. It's a crime. You cannot evict somebody without a court order. One also thing to add on, because this also may happen, your landlord can't, let's say, shut off your electricity or shut off your water because you don't pay rent. That's what's called a diminution of essential services. So they can't take away services that you need for life simply because they can't get rent from you. That too is also a crime.
Got it. Would they be able, if the landlord changes the lock, would they be able to, or would a tenant be able to hire a landlord, or a locksmith and change it back?
I think it depends upon the facts, but honestly, if it is the landlord who changed the lock, that means that new lock is now evidence of a crime.
Mhm.
So I would say make sure you at least have documentation, i.e. a police report, that affirms that this criminal act occurred.
Mhm.
Now, if you need to remove that lock and the landlord, for whatever reason, cannot be contacted, can't be available to change that lock, what have you, then yeah, if it's reasonably prudent to do so, then that may be the best course of action because people should be able to live in their place without fear of somebody walking up in there with, you don't want to have the door without any locks.
Mhm.
But I think that it depends upon the facts, and it has to be a course of action that seems reasonable in light of what happened. But just know that if you change the lock, you probably have to give your landlord that copy of that key.
Mhm. Got it. Got it. So the last question we have here: can I be evicted if my roommate doesn't pay rent?
Depends upon the lease. So for most uh, tenants who have roommates, most of the time everybody is, we call it, jointly and severally liable for the rent. That means that doesn't matter if one tenant pays, the other one doesn't, both people pay equal shares of it. You're all liable under the terms of the lease, and the most primary term is paying rent. So if one person doesn't want to pay, the other one does, then yeah, you could have a rent court action that kicks out both parties out because both are, like I said, jointly and severally liable for rent. Now, in my private practice day, before being here, I had a situation whereby the landlord liked the paying tenant and didn't like the non-paying tenant, and therefore a rent action was put in place only for the non-paying tenant. But that's because of how that landlord wanted to keep a good relationship with the person who was paying.
Mhm.
And that was the way we were able to negotiate that result. But in general, unless you have separate leases, yeah, your landlord can kick everybody out because they're not getting a rent and everybody's responsible for it.
Got it. All right. Well, I think that does it for all of the viewer questions that I'm seeing. So I'll turn it over to Cindy.
Awesome. Thank you, Tim. So we're at the end of the show, Douglas. The end is near.
Ah,
That sounds so ominous.
I
Sorry.
know, right?
I did not mean it that way. I did not
Only
mean it
one
that way.
o'clock.
And I'm still hungry. Getting hungry by the minute. But for those who are still with us and listening out there, of our fellow Marylanders, what do you think is the most important thing, or maybe one or two most important things for people to know if they're facing evictions right now?
I would say first, please contact a lawyer to at least know what your rights are. You know, and even if for whatever reason legal aid can't represent somebody, we do have referrals to other organizations who may be able to help. So by all means, make the call to figure out what may be your options. And then secondly, show up to court. It is a whole lot easier to present a defense on the record when you have that opportunity versus trying to undo that damage after the fact by way of a post-judgment motion or an appeal. It is tougher, and many judges are going to ask, why didn't you show up? One of the biggest issues we see in rent court is that people don't go to court. And if the tenant don't show up and the landlord's there, it's a default judgment for the landlord. They don't have to say anything. They win. So if you want to have a chance, you got to be there.
Yep, absolutely. I think those are the very common things I see sometimes when someone comes to us and we cannot end up helping them, is because they already had that default judgment and there's really, no good reason that they missed court. Either they thought it wasn't important, or they just didn't feel like going that day. So again, get a lawyer as soon as you know a case is going to court. Talk to us early. We're a free organization. Thank you so much, Douglas, for speaking with us today. I really appreciate that. And I know you're super busy right now because of all the evictions that are going on too.
Yeah, fun
Yeah.
times.
Yeah.
But it is any way to get this information out, the better. So I really appreciate the opportunity. Thank you for inviting me.
Yep,
And
of
thank you
course.
to you as well, Tim.
Yep. Yep.
Thank you,
And
Doug.
Yep, absolutely. For our viewers out there, thank you for sticking with us this far. I know it's a bit longer presentation today, but hopefully, spread the word, spread the knowledge, share this video if you think it's helpful for people. And in terms of next week, I'm actually going to be speaking with Tim again. He's going to come back. And I don't think either of us are super experts when it comes to frauds, but we are going to talk about the common frauds out there that we see and hopefully have some useful tips for you on how to avoid them and what happens if you do fall victim to a scam. What do you do next? So again, share videos if you find them helpful, and everybody have a great rest of the week and have a great rest of the Tuesday afternoon. Thank you.